good morning, good night, good afternoon, wherever you are. We are worldwide and it's morning, afternoon, night somewhere. So thank you for joining. That's great. Sid, great to see you again. It's been quite some time. I'm excited that you were willing to make yourself available to speak in this occurrence of Resilience Reimagined, the Dean Speaker Series. I am, you guessed it, Alexander Siedschlag, the Dean of the Worldwide College of Arts and Sciences at Embry-Riddle Aeronautical University. We are proud to have 3 colleges of arts and sciences, and I'm proud to be the dean of one of them, that is the Worldwide College of Arts and Sciences that operates across the United States, across the country, and around the world. So therefore, this speaker series is very important, where we go to where we are, as you know, shedding light on resilience, a persistently evolving concept in different areas and domains from different perspectives. I'm excited that we have Sid here today to address to speak about constitutional limitations in national security cases and the government's response, therefore focusing on resilience in the legal system. Sid is currently the General Counsel for the Special Inspector General for the Troubled Assets Relief Program, where he leads a legal team providing legal and strategic guidance on fraud investigations nationwide. He has done, as you see in the announcement on Eventbrite, a couple of important things in the legal field. I just want to point out that he has also been an educator, among other things, teaching criminal law and procedure at the Federal Law Enforcement Training Center, at the FBI Academy, at Quantico, Virginia, and at the DIA Drug Enforcement Agency headquarters. So if you like to learn more about our college and its program offerings and what the college does, you may follow the link that I have put in the chat. But for the time being, please welcome our speaker, Sid, and focus your entire attention on his presentation that I know, because I've heard it before in a different context, is going to be enlightening and exciting. And once again, thank you so much for joining us. And thanks, Sid, for being our speaker. And please take it away.
Well, thank you very much, Dean. I appreciate that. I was very happy to accept the invitation to participate here. One thing I will point out is I had 2 requirements. Number one, I have to give a disclaimer. Basically, any opinions that you hear are mine and mine alone. They don't necessarily reflect the views of SIGTARP, where I work, or the Department of Treasury, or the government. The other requirement is I have to tell a lawyer joke whenever I make a presentation. So here's a quick one. How can you tell if a lawyer is lying to you? Answer: if their lips are moving. Now, putting those 2 together, we're going to talk a little bit about what lawyers who are working for the government, prosecutors, face when prosecuting national security cases, the kind of challenges that you run into in terms of bringing evidence out in court in order to get a conviction, and also the responses that the government, and when I say the government, I include the courts, the responses of the government to some of those challenges. Before we get into that, I would want to note that even though these are challenges to being a prosecutor here, I wouldn't want to have it any other way. I am glad that I don't work in a system like in, let's say, Russia or China, North Korea, where the prosecutor wins every case. It's, I think, important for all of us to recognize the fact that the government, as a prosecutor, sometimes loses, and sometimes the courts do not find things our way. And that's an important aspect in understanding that it's a free country and not an authoritarian regime. So again, I recognize that we have our challenges, but that's a good thing. All right, here's where we're going to go. Here's our roadmap. We're going to first talk about some of the constitutional limitations I mentioned before, in particular, 4th, 5th, 6th Amendment of the Constitution. We'll talk a little bit about how the Miranda rights work, the 6th Amendment, classified information, the specific challenges that you have when using classified information in the course of a criminal investigation, and then the exclusionary rule, which applies broadly throughout the criminal justice system. So that's kind of the roadmap of where we're going to be going. Let's start going. The 4th Amendment. All right, the 4th Amendment basically says that we are protected from unreasonable intrusions into our homes by the police or other government agencies. Now, I'm not going to simply read slides to you because you could read yourself. I'm here to kind of use the slides as a launching pad to talk about these concepts. Now, the whole idea of the Fourth Amendment is to give people a reasonable expectation of privacy. And the particular locus, as they say, the particularly sensitive zone is your home. Businesses tend to get less protection. Why? Because they're just not viewed as being as sensitive by the courts. Now, we have to get a search warrant if we want to actually search a premises. And that is the general rule. It has to be reasonable under the Fourth Amendment. And you have to get a warrant that pretty much describes what you're looking for. Where does all this come from? It comes from our country's experience, basically, under British rule. The colonialists were deeply offended by many of the British tactics of simply going into people's homes, looking for evidence, looking for things that might indicate treason towards the crown. And based on that, they decided to set up a system in our country where the government would not have that kind of carte blanche. Now, when talking about search and seizures, a couple of important things. Again, you have to have a warrant that has to be reasonable. What does that mean? Well, it has to make sense from a practical perspective for a reviewing judge or a neutral magistrate, as they say, who looks over the request for a warrant and says, yeah, I think this makes sense for you to go into somebody's home or business and look for some of this material. Now, the search and seizure has to be based on probable cause, but the reality is, I always tell investigators that I'm working with when I'm reviewing a search warrant, you need two kinds of probable cause, or PC, as we say in the business. If you're looking to search a particular location, you have to, number one, show that there was probable cause that a crime actually occurred. That's what you're looking for. So you're looking for evidence of that crime. But number two, you have to show that it's probable that the evidence for that particular crime would be located in such and such a location. It doesn't have to be absolutely certain. Sometimes you go to a particular location, you had good reason to search, and you find nothing. And there's nothing illegal about that. But you have to at least show up front that you probably will find evidence there based on your experience and other information that you might have. Now, if the warrant's obtained from a judge, the warrant must describe what you're searching for. So what does that mean in practical terms? If you're looking for a stolen automobile, it would make sense for you to look for it in someone's garage. It wouldn't make sense if you're looking for a stolen car to be looking in someone's hotel room. So it has to be reasonable. It has to make sense in that respect. On the other hand, if you're searching for stolen jewelry, that could be in almost any location. So again, you would have the opportunity to search every nook and cranny in someone's residence if what you're looking for is stolen jewelry. Every search warrant is going to depend on the specific facts of the case and how those facts are laid out to a judge who reviews that warrant and decides, yeah, I do think a crime has occurred, and it does seem probable that there is some sort of evidence that can be found in this particular location. Now, because this does pose problems for law enforcement, and at times those problems seem to not be in the best interests of society, the courts have carved several exceptions into the search warrant requirement. Even though it's the general rule that you should have gotten a warrant, there are some exceptions. Let's talk about them. Number one is consent. You have the right to be safe from searches and seizures in your house without a search warrant, but you always have the right to consent to that sort of a search. You can agree to it. Secondarily, you can even agree to a search of your body, your pockets, your bag, your knapsack, all of that. That is one important aspect of Fourth Amendment law, that frequently police will look for consent or request consent. Let's talk about that in the airport context, especially since your university has a direct focus on aviation. When I used to prosecute airport cases, the DEA agents would typically walk up to somebody who appeared to be suspicious in the way that they were carrying themselves. Perhaps they bought a one-way ticket. That's one of the classic signs where someone buys a one-way ticket and they have no luggage. There's a real fear that there's a drug carrier or a mule who's actually transporting drugs in those situations. They would walk up to the individual, say to them, "I'm from the DEA," show their credentials. "Do you mind if we look in your fanny pack? Do you mind if we look in your handbag?" And frequently the individuals would say, "No problem." Why would drug dealers do that? Well, for a couple of reasons. Sometimes they think they can brazen it through. Sometimes they think that they've gotten the drugs in a hidden enough compartment that they won't be found. Sometimes they're just nervous and scared and say what they say. In any event, the DEA often utilizes that consent exception. Another exception that you might be aware of are drug sniffing dogs. If a drug sniffing dog was to alert in the course of walking by someone's luggage, and by alert, I mean that they are trained to act in a certain way, sit down and signal to their handler that they smell what appears to be narcotics, the police do not need a search warrant. The DEA or customs or whoever it might be would simply go into that luggage. Why? The courts have said that really is the equivalent of establishing probable cause, because those drug sniffing dogs, or bomb sniffing dogs for that matter, are considered to be so consistently accurate that it is not an unfair substitute for a search warrant. So in those cases, in the airport cases, the DEA utilizes consent, utilizes drug sniffing or bomb sniffing dogs. Another example, exception, is the plain view doctrine. What does that mean? Police are able to go in and take contraband material if it's in plain view. When did that become very, very common? Well, with the introduction and rise of the automobile in the 20th century, very often criminals who are not careful or smart would leave a gun or other contraband, other materials sitting in a car, visible to anyone walking along the street. That's called the plain view doctrine. If police see drugs in a car, if they see what appears to be an illegal weapon in a car, they can simply go into that car and take those materials, pursue the case, arrest the individual. That's called the plain view doctrine, because they have the right to see whatever the rest of the public can see. The same would be if there was some criminal activity in the first floor of somebody's residence. If it was visible from the street and a passing police officer saw it, well, that's called plain view again, and they could simply go into that residence without a warrant. The last exception is, again, another kind of a common sense idea: exigent circumstances. Sometimes there just isn't time to get a search warrant. What would that be? Police are walking by a residence and they hear somebody screaming, help me, I'm dying." They do not have to go to a judge and get a search warrant and break into the place, show the search warrant. They can immediately kick in the door and rescue the person who's being attacked. Those are exigent circumstances where it just doesn't make sense to get a search warrant. The concept there really flows from a famous quote that says the Constitution is not a suicide pact. That was something that Justice Jackson said back in 1949. And what it means is, yes, we have all these very, very important constitutional rights, but they have to be understood and applied in a way that utilizes reasonable common sense and allows the police to do their job. All of these constitutional rights basically are balanced between protecting individuals' privacy and personal rights from government intrusion versus the ability of police to do their job and protect the public. And it's that balance that the courts are trying to strike. And that balance that allows exceptions like exigent circumstances, where the police can just use their experience and senses to try to protect the public. Now, on to the Fifth Amendment. Now, the Fifth Amendment says that you can't be compelled to testify against yourself. That's basically what it says. What does it mean in practical terms? It means that I, as a prosecutor, was never able to call the defendant to the stand. The defendant can testify in a criminal case if they want to, but I can't require someone to testify. I can't require someone to answer questions. The police, the FBI, government agencies can't require someone in a criminal case to provide incriminating information about themselves. Now, it goes beyond simply, I can't call someone to the stand. As a prosecutor, I couldn't even argue to the jury. Wait a minute, ladies and gentlemen, this individual has been charged with some very heinous crimes. I know if I was charged with those crimes and I didn't do them, I would be on the stand explaining to everyone why I was innocent. Instead, they have sat there, remained silent, haven't said a word. You could never make that kind of an argument as a prosecutor. The court would instantly find a mistrial and the prosecution would be over. In fact, the courts have been very, very sensitive. You can't even come close to that. You can't even hint at the fact that a defendant didn't testify on their own behalf. You couldn't say something like, we've heard from lots of witnesses in this case, but who haven't we heard from? Let's think about that. Anything like that, anything that implies to the jury that you should have heard from the defendant, that would be grounds for a mistrial. So it's very, very different from the concepts that you may be used to or familiar with in a civil trial, where, for instance, I currently work on fraud matters, which can be both criminal and civil. In a criminal fraud case, all these rules apply. You can't force the defendant to say anything. But when I used to go down to Florida and prosecute Medicare fraud, if we brought a civil case against the doctor, we could take his deposition. We could say, wait a second, can you explain to us why you have all these billings for patients that apparently never saw you? And you could force them to give some sort of an answer. And if they did give an answer and say it was all a terrible mistake, then if you did go to trial, you'd at least know what their defense is, and the government would be able to then counter those defenses. That's in a civil case. You're allowed to do that. In a criminal case, you are not. Now, the courts have been so sensitive about protecting this right to self-incrimination that in a landmark Supreme Court case called Miranda, the court said, not only is it someone's right to remain silent, but you have to inform them of their right. So that kind of cuts against the grain that typically exists in all legal situations. You've probably heard about the old saying, ignorance of the law is no excuse. Everyone is presumed to know about the law. Yeah, that's generally true, but not when it comes to the Fifth Amendment. The court said that even though individuals theoretically should know that they have the right to remain silent, you have to, as a government agent, inform them of their rights before you can interrogate them. We want to make sure that any admissions that a criminal makes, criminal defendant, I should say, makes are voluntary admissions. So that's basically the backstory to Miranda, and it demonstrates the great sensitivity, again, the courts have to protecting that particular right. Now, let's get into the specifics of it. You guys have probably heard the Miranda warnings a million times, but this is one of the few times I actually will read from the slide directly. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to the presence of an attorney during questioning. If you cannot afford an attorney, one will be appointed for you. Why do I read those words exactly? Because the courts have said you have to basically use that script and stick to it. There was a court case where the police modified it slightly, and they said anything you say can and will be used against you or can be used for you in a court of law, which is literally true. You might say something that actually would be beneficial for you, and it might actually be what's called exculpatory information, and that might be to your benefit. But the courts have said you can't deviate from this script. So even saying something like that, that's literally true, is not going to be permissible, which is why police officers memorize this, why you hear it exactly the same way in every cop show for the last 50 years. They have cards where the Miranda rights are written out. And that is why police are very careful when they do interrogate a suspect who wants to give consent, who wants to waive their Miranda rights, to get it in writing, so that there are no later issues, no successful motions to suppress that statement. You want to demonstrate that whatever they said, that was said voluntarily. Now, a couple of important considerations are that Miranda warnings are only required if someone is in custodial interrogation. That means, obviously, if they've been cuffed, if they're being taken away in a police car, if they're in jail, you're in a custodial situation. But the courts have said that can happen even before you're actually formally arrested. If the police are basically detaining you and you don't have the freedom to move, then you are deemed to be in a custodial situation and you have to give someone their Miranda rights. So remember when I told you about the DEA cases I prosecuted in the airport situation? I would typically ask those DEA agents, now when you approach that individual, were they free to go at that moment? And they would say, oh yeah. I would sometimes even go further. So if they had turned on their heels and walked the other way, would you have stopped them? And they would say, no. The reason I would get all that on the record is to make sure that there were no grounds to suppress whatever that person said. We would make it clear that anything they said was not said in a custodial situation. At that point, before the police had performed a search or a dog had been alerted, that individual was just having a discussion with the police. DEA agent, FBI agent, police officer, like any of us, they can walk up to a person and ask questions. We can all ask questions, and it's up to that person to answer, not answer, walk away. Everything changes when the person is in custodial circumstances. That's when Miranda clicks in, and that's when you have to give those Miranda warnings. Now, I mentioned the word interrogation. Interrogation obviously conjures notions of someone sitting there getting question after question designed to bring out facts. But the courts have said that it can be situations where there aren't even specific questions being asked. The most famous case is known as the Christian burial case. What happened in that case, the police picked up a suspected murderer. They believe he had killed a young girl, but they didn't have the body. What did they do? They put him in the backseat of the police car. They were taking him down to the police precinct. The two police officers were talking to each other with the person being part of the conversation, but never asked them any questions. They were simply saying, it's a real shame that that poor girl is out somewhere, lying there in the cold, and the parents can't give them a decent Christian burial. The defendant started to cry, broke down, and said, okay, this is where I put the body. You can go find it there. The courts found that that was even deemed to be a situation where Miranda rights had to be given. Why? Even though they never formally asked a question, they were making statements that they knew were very likely to elicit something from the defendant. And a situation like that, again, Miranda clicks in. That is deemed to be an interrogation, even if questions aren't being asked. Now, since obviously the Miranda doctrine does impose burdens on the police and sometimes could result in situations where public safety can be minimized, if not totally endangered, there are exceptions. This is where the courts and the government have responded to some of these limitations and have tried to carve into the rules some limitations that would allow for more effective policing. Number one, let's talk about these circumstances. The public safety exception. That means you can ask questions if it's designed to protect the public. What would be a concrete example of that? Well, a case that's been, of course, internationally known was the Boston bombing case. If you don't recall that case, the Tsarnaev brothers planted bombs at the Boston Marathon. killed a number of people, children, families blown up, because they opposed the government's position on Muslim rights, and they viewed themselves as fighting against oppression. When they finally captured the brothers, or I should say cornered the brothers, they got into a gunfight and were actually throwing explosives at the police officers. One of them died, one of them survived. It turns out that the police understood that they were heading down to Times Square to blow up some more people after killing people in Boston. They asked the surviving Tsarnaev brother, "Do you have any other bombs? Where are the explosive materials?" Even when he was on his hospital bed, even if he had had some narcotics. Why were they doing that? Well, because there could be explosives out there somewhere. There could be bombs, and it was important to locate them, and they weren't going to worry about Miranda rights. That was a situation where it was found to be appropriate to use the public safety exception. So you can ask a defendant things like, "Hey, where did you put that bomb?" Other examples would be if you're chasing a suspect carrying a gun, you're running through a neighborhood, through playgrounds, through backyards. By the time you catch up to him, he doesn't have the gun anymore. This scenario has happened in many cases. The police can immediately ask, "Where did you throw the gun? Where is the gun?" Why? Because if some child was to pick up the firearm and potentially hurt themselves or others, it would be a real tragedy. So the priority there is to protect the public, not to worry about the Fifth Amendment. So you can ask in a situation like that, "Where is the gun?" Another very interesting exception is the undercover interrogation exception. What does that mean? Well, very often individuals who don't want to talk to the police will gladly talk about their crime to fellow criminal defendants in jail. Sometimes they'll spontaneously mention it. Sometimes with a little prodding, they'll talk about what they did, where the evidence might be, all sorts of incriminating information. The police know that. Sometimes they even pay jailhouse informants to elicit this kind of information. There have been cases where those admissions have come out through jailhouse admissions. Sometimes even undercover police officers have been placed in prison in order to get the information. The courts have said that's okay. Even though the individual is clearly in custody, they're in jail, they're not in a situation where they are likely to be intimidated by the police. It's not the same intimidation factor as a uniformed or an armed police officer asking you questions and you feel you're compelled. When they shoot their mouth off in prison or in jail, the basic rule is that that undercover situation is not a violation of Miranda. So that's a useful tool for police officers, for the criminal justice system. And it's also, quite frankly, fair in my estimation, because again, the person isn't under any coercion. They're just choosing to talk about whatever crime they were involved in. And the last exception is the routine booking question exception. When you talk to someone at the time that they're being booked, you find out their name, their address, their age, social security number. You can ask all of those questions without giving them Miranda rights. You can also ask them, "Have you taken any drugs?" Why? For their own benefit, in case they have to be put on some sort of a medical watch, in case there's an overdose or something along those lines. The interesting side note to that is frequently in drug cases, I'll hear even from defense attorneys that the defendant will say, "Hey, they never read me my rights. Can I go free?" Well, in many drug cases, for example, an undercover buy, the government doesn't need to interrogate the individual. The buy is clear, it was perhaps videoed, and there's no interrogation going on. So Miranda only affects cases where the government is interrogating someone. So in those cases, it's not good form. The police should give someone the Miranda rights when they're being arrested. But if there's no intent to use an admission by someone, It's no harm, no foul. It doesn't really matter in the end. Now, moving on to the Sixth Amendment. This is where we get into national security cases. Basically, under the Sixth Amendment of the Constitution, you have the right to confront any witness against you. It's called the Confrontation Clause. Now, what does that mean as a practical matter? In cases involving classified information, the government would often have what's known as a Hobson's choice. If it wants to preserve some sort of covert source of information, at the same time as it needs to provide due process and discovery rights to a defendant, the government has to make a choice. Am I going to, as a prosecutor, am I going to reveal this kind of information, or do I run the risk of not giving it to the defendant and essentially undermining the prosecution? Now, when I say covert information, it could be two different types. It could essentially be an undercover source, someone who's been placed in a terrorist organization. You could have an agent undercover or an informant within Al-Qaeda, ISIS, whatever the group may be, or it could be a law enforcement technique. So what do I mean by that? Give you a concrete example. And this is one that I'm obviously not revealing anything that is not in the public domain. But at one point, it was not widely known that intelligence agencies have the ability to shoot a laser beam at a window. And by measuring the vibrations of the window as the laser bounces back, they're able to basically reconstruct conversations in that room. Years ago, I worked at the Pentagon, and I was told about that. Now, that's in the public domain now. But if that technique was used in a case, and that was the source of information, and if it wasn't publicly available, clearly the government would try to protect that sort of information. So what happened? Congress responded to this Hobson's choice by coming up with SIPA. And as we said in the previous file, that's the Classified Information Procedures Act. The goal is to stop what I was just describing as gray mail, but still allow the defendant to put on a fair defense. It's basically that balancing I referred to before. And when it's called gray mail, it's not quite blackmail because the defendant's not doing anything illegal. But in those cases, the defendant is seeking information which they may or may not really care about, but with the hope that it will be so sensitive, the government will either drop the case entirely or offer them a much more lenient plea deal, because they have the leverage of saying, if you take me to trial, you're going to lose all of your secrets, or you're going to have to reveal your sources. Under the SIPA process, which again is aimed at balancing the needs of the government to protect this confidential information while still giving the defendant a fair trial, the first step is to try and narrow the issues. The prosecutor could go before the court and say, you know, Your Honor, we have some information that ordinarily we would turn over to the defendant in discovery that they would be entitled to, but it has all sorts of sensitive national information. And we think it's not really necessary in their case. They've asked for it. So the court would have what's known as an in-camera and ex parte hearing, which is just the lawyers' Latinisms for meaning that it's going to be in the judge's chambers. It's not going to be in public. And the defendant, of course, will not be a part of those discussions. It would defeat the whole purpose if you were discussing that information in front of the defendant. So there'll be a in-chambers hearing with just the judge and the prosecutor where you go over that information, and the court can decide if it's really even necessary to turn it over. Now, what if the court says, yes, I think this information is relevant, and I think the defendant may in fact be able to use it in their defense. I am going to rule that some of this must be turned over. Well, the SIPA process continues then too. Government has a few options. Government can say, okay, I don't have to turn over all of this information. I can substitute information that will still allow the defendant to understand what's going on and formulate their defense. What's a real concrete example? Well, as you may know, in your state of Florida, just a little bit further south in down 95, former president of the United States is being charged with criminal violations of various statutes that involve classified information. One of the supposed classified documents, and again, I'm not involved in that case. Everything I'm saying is just from the public domain, involves supposed plans to attack Iran. Let's say that that hadn't leaked and that information wasn't out. And you're in a case where you have to reveal to the defendant which classified documents you say they had negligently or improperly handled and had revealed. You could change the exact nature of the document and say they were plans to attack country A and not say they were plans to attack Iran. The argument to the judge would be, Your Honor, it doesn't matter what particular country's attack plans were revealed. The gist of our case is there were attack plans that, if revealed, would help another foreign country. It doesn't matter which one. So why say Iran? Why put that particular country on notice? And if the judge buys that, you could substitute that information, and that would be what would eventually go to trial. Attack plans against country A. Another technique would be to summarize information. If the court approves of the summary, you don't have to use the actual document. Similarly, you kind of can fuzz up that information. If you were going to reveal a statement that was made by the defendant on a particular day, April 9th, 2020, that might very well reveal exactly who your informant was, because they would know who they were talking to on that day. But if you could say the defendant made the following statement sometime between January 1st and June 1st, 2020 in a conversation, that fuzzes it up because they might have had a lot of conversations. There might be a number of people that might be the government source. In those situations, the government has revealed enough that the defendant can come up with whatever defense they need, but not necessarily reveal the exact source of that information. Another technique the government has is it could simply stipulate to certain facts. So let's say an individual at some point had said to his co-conspirators, I think we should kill this plan. Let's not go through with it. That would be arguably exculpatory information. Well, if the government was to say exactly how they knew of that, exactly who told them, that would pretty much reveal who their informant was in that organization. Instead, the government can simply stipulate that on a certain time, at a certain date, the individual made the following statement. So that gives the ability for the individual to defend themselves while not revealing the source. A couple of other strange things with SIPA. There's the silent witness rule. What that means is that the judge and the jury, they hear the information, but it's not broadcast to the general public. Other aspects of it is that both sides must give notice if, after all the discovery and pretrial motions, they intend to use classified information. That's one of the very unusual times where a defendant must disclose parts of their defense. It is generally held that defendants don't have to reveal their defense. There are some exceptions to that. Sometimes they have to do it if they expect to present expert testimony. There are other circumstances where they have to reveal that they're going to use an alibi witness, things like that. Here is another circumstance where if the defendant wants to disclose parts of their defense, wants to use classified information, they have to reveal. Why? To use a real world example, if hypothetically Edward Snowden was brought to the United States and charged criminally, Edward Snowden, of course, being a CIA contractor who's now living in Russia, who revealed classified information during his work as a contractor for the government. If he intended to make certain statements about government programs, or if he knew about government informants, then at least if he has to give the government notice of that defense, it gives the government time to actually pull that undercover person or to change that particular program so that it's no longer vulnerable. That is the concept, to give the government basically a heads up. Or if there's no other option, the government may in fact decide to drop the case. That would be the worst case scenario from a prosecutor's point of view. But if the information is just too sensitive, the defendant has the information in their head. It's not the government revealing it to them, but it's things that the CIA agent or the FBI agent who's being prosecuted knows and they intend to reveal. If you want some background information or see some interesting stories about that, there was an old movie called Donnie Brasco involving an undercover FBI informant. And that illustrates this principle that once you have revealed that someone is undercover, you need to pull them out very, very quickly, because whether you're talking about the American mafia or terrorist groups, they're probably going to be killed. So that's an interesting movie. It's an old movie starring Johnny Depp. You might want to check that out. Under international espionage circumstances, the Israelis at one point had a highly placed agent in Syrian defense establishment. Eli Cohn was his name. They were constantly debating when to pull him. He was giving them great information, but the risk was increasingly evident that he was going to be revealed. He finally, in fact, did reveal himself when he knew about an attack on a kibbutz that he signaled to the Israelis, but by doing that, he revealed himself, and he was in fact captured and hung by the Syrians. There's a book called Our Man in Damascus, and there's a TV series called The Spy more recently, but it illustrates that quandary the government has. If you're going to use information in the legal system involving a confidential technique or a confidential source, you run that risk. You run the risk that it will be revealed. And sometimes you have to make very hard choices. Now, moving to our last concept, the exclusionary rule is another challenge that the prosecutors face in national security cases, but it's very similar to the challenge that prosecutors face in every criminal case. Basically says that evidence taken in violation of someone's criminal rights will be excluded from court. It's just not admissible. Now, let me give you a hypothetical. Let's say there have been a series of child murders in a particular city. Experienced police officer sees a guy driving down the street, doesn't have any probable cause to pull him over. Nothing illegal has occurred in his vision, but he just has a sense that something's wrong with this guy. Pulls him over, cuffs him, looks in the trunk, finds the body of a dead kid. In a situation like that, since there was no probable cause, under the exclusionary rule, the individual goes free. Even though the cop had a hunch, you can't arrest someone on a hunch. You can't search based on a hunch unless you fall under one of those exceptions I had mentioned before. So that has been highly controversial. Many years ago, famous Judge Cardozo said, should a criminal go free because the constable has blundered? And that is what irks so many people about the exclusionary rule, that it basically takes good evidence, probative evidence, and says you can't use it because the way it was gathered. Those who defend the exclusionary rule, and the courts so far, have said, yes, but in losing that particular case, we uphold the broader rights of society to be free from unreasonable searches and seizures. So it's worth the price that we pay in that some criminals may go free, but it will protect our general constitutional rights. The counter to that counter argument is that other countries like Canada have a well-respected free judicial system, and they don't have the exclusionary rule. Nevertheless, it is our rule. It's been extended to what's known as the fruit of the poisonous tree. So what does that mean? Basically, you can't get any follow-up evidence that you got if the initial search or the initial government activity was illegal. So if the government illegally searches a car and you find a safe deposit box key, you can't take that key, look in the box and say, aha, now we have some more evidence. Not only is the original search material suppressed, anything that leads from that, anything that flows from that is also suppressed. Now, like almost everything else that I've talked about, there have been some exceptions, and the system has responded to what appears to be the harshness or the undue interference with law enforcement. So let's talk about those exceptions. Number one, there's the good faith exception. If there's a technical minor problem with a search warrant, the wrong address was typed in, the courts are not going to suppress that information. If the police are essentially trying to do the right thing and there was a minor problem along the way, the courts have said, we're not allowing the defendant to benefit from that circumstance. Another example would be inevitable discovery. What does that mean? Remember the hypothetical I just gave you where the cop on a hunch pulls over that car? Let's say instead of that, the cop noticed a broken taillight, pulls the car over, which is appropriate to give them an equipment violation. In doing that, ask the driver for their license. Turns out there's no license. The car isn't registered. So of course the individual is taken out of the car, they're arrested, and the car has to be towed away. It can't be driven. It's not registered. It's not a legal vehicle. In a situation like that, where the police would ordinarily do what's called an inventory search, the courts have said, well, if it's inevitable that that body would have been found, because what would have happened is the car would be towed back to the impound lot. Someone goes through it, as they do in police impound lots, inventory it just to make sure there are no drugs or bombs or something like a dead body, hazardous materials. They inventory the car. Someone would have seen it, and it was going to be found anyway. Similar to that is the independent source doctrine. So if at the same time as the police had illegally pulled over that car, a neighbor had stopped into the police precinct and said, you know, I think I saw my neighbor taking what looked like a body and putting it in their trunk, and this is the kind of car they're driving. That would be an independent source. So even if at the time the police were illegally getting this evidence that could be suppressed, if they could show, hey, there was a separate way we would have gotten to this, and we would have inevitably done it, that's something that they would have been allowed to pursue. So that gives you an idea of the tension that prosecutors face in national security cases, the tension between giving someone a fair trial, which they're entitled to, and making sure all of our rights are protected without unduly undermining the ability to get information and to pursue some very, very evil people like ISIS, Al-Qaeda, drug cartels, etc. That brings us to the end of my planned discussion, but I'd be happy to take some questions if there are any.
Wonderful. Thank you again so much, Sid. And I am certain there will be a lot of questions. So who would like to go first? And you could either take the mic or you could just type in the chat and I'll then read it out to all. Who wants to break the ice?
Well, I'll do it.
Okay, great, John. Go ahead.
Really not a question. I was just really impressed with how you presented the information. In the military, we had, when you're talking about Miranda rights, we had what we called Article 31. We actually called it a charge card. And whenever you suspected someone of breaking one of the Uniform Code of Military Justice rules, you'd have to read that. So it's not exactly the same as the Miranda rights, but it's very, very close. And it just shows how hard this country tries to give people an evenly balanced chance at getting justice, even when they're accused of something. I mean, and we literally had a card you'd have to read from. And you know, what amazed me was how many people, and maybe this is a good question if you've experienced this, when people are read their rights, is it surprising how many still talk anyway? And
Yeah,
don't lawyer up?
that is an interesting facet, because when Miranda came down, there was this hue and cry from law enforcement saying, well, now nobody's ever going to confess to a crime. We'll never hear. But you know what? People do. And you can probably cite to a couple reasons for that. There are folks who just want to get it off their chest. There are also folks who start talking because they think they're going to outsmart the police, that they're going to basically talk their way out of problems. Most of the latter part of my prosecution career has been white collar fraud. And people who commit fraud, they do talk. They take the stand in criminal cases. Why? Because all their lives they've gotten away with scams, and they've been much more clever than the people they're dealing with. They're slick, and they think, I'm just going to talk my way out of this one too. Of course, they haven't dealt with a prosecutor firing questions at them. They haven't dealt with the situation where the person opposing them has done their homework and is prepared to shoot holes in whatever stories they make. But I think that's a secondary factor. Some people want to get it off their chest. Some people are simply thinking that they can talk their way out of it. And it's very useful for the police, even when someone gives them a completely BS story, which is legalese for false information. If someone provides false information, it's still useful because you're what's called locking them into their story. And then later at trial, it's hard for them to change gears, because oftentimes what they say didn't make any sense, and it didn't make any sense, but later on they can't say, well, I didn't mean, well, they can say, I didn't mean what I previously said, but it will completely undermine their credibility. So police don't really mind when someone tells them a ridiculous story. In fact, sometimes it's helpful because the story is so ridiculous that you say, well, that doesn't make any sense for the following reasons. And then the person realizes, okay, in for a dime, in for a dollar, maybe I'll tell the truth now at this point. So it all depends on the individual. Sometimes they'll continue to stick to a false story. There are drug dealers from one country, I won't name it, but they're notorious for simply sticking to a story. And I've heard stories of people saying they deny their identity when you show them a photograph. Wait, this is you on the passport, right? This is you. No, that's not me. Wait, we just took your fingerprints. They match your prints. Not me, not me. So, it's interesting. The Miranda doctrine has not stopped people from confessing to crimes. You hear about it all the time. People do confess. Sometimes it's years. Sometimes it's years later. Yesterday, Joran Vandersloot finally confessed to murdering that girl. 20 years later.
In the interest of time, I'd like to hop on to the next question. Janice, I see your hand, but as a courtesy to those who are in the chat, I'd like to take the chat first. And
okay.
there are two questions. So JR, who is one of our colleagues here at the College of Arts and Sciences, great presentation. Gray mail is a new term for me. How often is that effective? Does that make a lot of a difference? How often is that seen? Can you give an indicative volume from your experience, Sid?
Yeah, I think prosecutors face it all the time. Okay. And again, it's called gray mail because it's not quite blackmail. People are entitled to their discovery, as it's called in the criminal process. But defense attorneys know darn well that by demanding all of this information, you're putting the government to this quandary. What are they going to reveal? And most cases end in plea agreements. Most of the time, what defense attorneys are trying to do is to get the most leverage on their side to get the best deal they can for their client. And by creating a burden for the prosecutor and a risk that information that's really sensitive might be revealed, you get a better deal. Because it's like any bargaining situation, it all depends on the leverage between the parties. So it's something that a criminal defense attorney can, and from the perspective of their client, that narrow perspective, they should do it.
Next question on the chat. Yeah, thank you. And from John Hamilton on slide 15, where you discussed inadmissible evidence, I believe. So John says he didn't see the attenuation doctrine referenced. If that is correct, if that's not under, could you just very briefly expand on that? Thank you.
You didn't blink. I skipped over it, thinking it was self-explanatory, but once again, like a lawyer, I didn't think like a normal person. It just means that at some point, the link between the illegal activity and the evidence becomes so attenuated, stretched out through so many links in the chain, the court will say, you know what? I'm not going to prosecute this. I'm not going to punish the prosecutor 3 years after the fact when there are so many intervening steps. So it's a situation where it's just been stretched so much, attenuated, that they're not going to apply the doctrine. That's what it means.
Thank you, Sid. And with that, Janice, thank you for your patience. Janice is also a faculty colleague here at the Embry-Riddle Worldwide College of Arts and Sciences. Go ahead, Janice, please.
I guess my question is, with the Fourth Amendment being as prescriptive as it is, how in the world did they get by with the Jane and John Doe warrants, where they just came in and searched for whatever they wanted to, no matter what was going on in the late 60s?
Well, I mean, again, they would present the evidence to an independent magistrate. I think at various points in our country, the leniency of the magistrates in terms of determining whether probable cause has been established and whether the Fourth Amendment rights have been met probably could be stretched. But, you know, there are times where you may not know the individual in particular who you're searching for, but probable cause can be demonstrated. You know, you'd have to give me a specific example if there's a particular case that you're referring to.
I lived in a Chicago neighborhood that backed up to another suburb. It was filled with Northwestern students and hippies. And every day, twice a day, the other suburban police and the Chicago police raided their apartments with John and Jane Doe warrants. Obviously, they were looking for drugs, but still, it was excessive.
Yeah, you know, there is no system in the world, no governmental system that is perfect, and our judicial system is not perfect. In those cases, again, I don't know what the result was. I have heard cases even more recently than that, where the police, the main goal was to get the drugs, not necessarily to get a prosecution. So they've gone in with defective warrants and they seize the drugs, because even if the Fourth Amendment is violated and you can't prosecute someone, they don't get the contraband back. The Fourth Amendment doesn't say you hand someone back their drugs or their bomb or their gun. So there have been times where the police have done things like that. I've heard cases where there have been illegal immigrants involved and the search warrant was deemed to be deficient. There wasn't probable cause, but the government was able to seize all the drugs and deport the individuals, and they figured that was good enough. I have never been involved in those cases. I've heard stories of those cases, and all I can say is I have never seen a time where we've requested a warrant where we didn't feel we had adequate probable cause and fully explain it to a judge. And I've never had a case where a judge didn't carefully read the warrant and consider it. That's just been my experience.
Thank you so much.
Thank you, Janice and Sid. And that brings us to the hour. So thanks, Sid, once again for taking the time to present to us. Thank you for contributing here with questions. Thanks for coming. I posted the link to our Eventbrite page in the chat. So if you would like to join, you know, one of the next occurrences, we already have 2 further ones scheduled. If you'd like to check them out under eventbrite.com or follow us also on Eventbrite, feel free to do so. Thanks again, Sid. Good to see you again. And
You're
take
welcome.
care. Have a great rest of your day, wherever you are. Bye-bye.
Thanks.
Okay. Enjoyed it. Take care, all.
I'm glad you did. Bye-bye.